If you guys just want to pull up a chair. Who's this?
This is my husband.
Okay. Do you have pertinent information that's going to be useful, or are you just here for moral support?
Just is gonna.
Okay.
He just speaks better.
On track. All right.
He speaks better because he's less emotional about it. So.
Okay. I know how that goes. Let me just open up the call here.
I didn't know this building was here. Is this air conditioning?
So have you kind of processed a little bit about what I said? As far as the pertinent information.
Yeah, I didn't print out the 5,000 emails. I just went through here and numbered each of them. And the ones I have proof of, I just put a check mark next to them, but some of them I don't because they just didn't happen.
So we'll go through this a little bit more in depth. Hey, I got a follow-up interview I'm doing right now at the 103. So I'm gonna have them reopen that call. I don't know how long it's gonna take though. So if you need me, if you need anything, just give me a call. What's up? No, this is for court order. So yeah, I'm gonna open up the call here in a second. All right, see. Okay, so I guess we can start. So just letting you know, you're not under arrest, you're free to go. This is going to be a voluntary interview. With that being said, I'd like to make sure everybody knows their rights.
Okay.
So I'm going to read them to you. You're not even being detained. All right. Technically, I only have to read them if you're being detained or arrested. And I'm questioning you about any kind of elements of the crime, or alleged in this case. So you do have the right to remain silent. Anything you say or do can and will be used against you in the court of law. You have the right to an attorney before questioning. If you cannot afford an attorney, one will be provided for you. So do you understand those? Mm-hmm. So once again, this is voluntary. You can leave if you want to. I just like giving people benefits of the doubt, especially in this circumstance, to be able to tell me their side of the story. Because I very much believe there's two sides of the story. Mm-hmm. Mm-hmm. So let me just show you what I have, what was provided to me, and you can say yes, you can say no. I've more or less validated them. So we're going to start out with you were served on, let's see, I've got a served date here, June 27th.
I'm not sure what day because I know she had come. She waited for a while one day, and I was in a patient room, and
let me look up the notes. I made notes.
It was filed June 28th.
That's when it was filed, but I don't know.
Okay, it was stamped June 27th. Let me see when it was. Date of service, so June 30th at 10:53 a.m. That sound about right?
Yeah, I mean.
So June 30th would have been, let me tell you right now, Thursday. So you probably would have been at work. Mm-hmm. Okay. So this is the injunction. We briefly went over the injunction. So I just want to, where are we at? So it says no contact, defendant shall have no contact with plaintiff employer or other person while that person is on or at court hearings and as checked. So they check the mark, email, fax, and mail. Does that mean you can call them?
It looks to me as though I can only email, fax them, or comply with the current management plan.
Okay, so you can only email, fax, or mail.
Well, mail's not even.
Oh, mail's not.
Can't
other.
even mail, right.
I don't know what other means.
So other is it says it
1
twice,
through
but
7.
yeah, the 1 through 7.
So I'm just going through this with you so I understand as well.
Okay, yeah.
So the first stipulation is comply with current or amended contact plan. Did you guys have a current or amended contact plan?
We have a contact plan.
Now, is that an unofficial contact plan?
Yes, it's not enforceable or legal
Okay.
or.
It's just an email.
I don't know if I brought it. I was gonna bring my computer, but I couldn't find my keys and we have a contact management plan, but it's just this really long.
So I just want to make this part very, very clear. I'm not arresting you on this.
Okay,
You're probably gonna have to go to court.
we are gonna go to court.
Yes. But I just want to put you at ease. I'm
Okay.
not arresting you.
I just don't
Meaning I'm
understand,
not-
I
I'm
don't
not hooking
understand
you
the
into
process
jail.
of what's going on right now
That's
even.
what I'm here for, kind of. So the first one is current or amended contact plan. You guys are, what did the contact plan stipulate?
In a nutshell,
Yeah.
she's not allowed on school property
Okay.
of
Now, just remember what you say is being recorded.
Right.
So just make sure that it's fact.
So it says I'm allowed to be on school property. I used to call it a ban, and my attorneys say it's not technically a ban because they're giving me a way out of it. So what the contact management plan says is that if I have any need to be present on any of the locations owned by Miami Unified School District, I have to email 2 school days in advance to get permission. That's what the
So
plan.
events.
Any event or
Okay.
taking your kid.
Doesn't matter what the event
No.
is, as long as you tell them beforehand.
2 school days beforehand, which is the reason
Okay.
for automation.
Okay.
It has to be approved.
So that's number one. I mean, but according to this, they probably wouldn't disapprove it.
Right.
Use only this certain email address. Has that been upheld? Have you been doing that? Okay. Email during business hours only, except in emergencies. So I'm gonna highlight ones that I have noticed that probably need some further explanation. No automated emails. This is probably the most specific injunction I've seen. No copy to students or parents on emails to the school. Nobody's alleged that you have, so I'm gonna skip that one. Only 1 email per subject. Once again, nobody's alleging that. No personal complaints about school personnel unrelated to either defendant's child or school events. So that more or less means whatever is directly pertaining to you or your kid at the school.
I don't know what this, I mean, I guess
I'm
means.
assuming don't make a complaint on someone else's behalf. I think is what that means. Well, once again, nobody's alleging that. So my biggest 2 are gonna be right here, are gonna be the email during business hours only, and business hours, what did you guys stipulate as far as business hours?
I don't know that anybody stipulated, but I would assume his business hours.
Not necessarily. It's not just what's his name, Lineberry. It's everybody. So whatever they deem as school business hours.
Yeah, I was gonna assume that it's school business hours and.
Okay. Well, if you were the school's business hours, what would they be? What is a reasonable time?
I guess when the teachers are working, I don't know what time those are.
Okay. Is it safe to assume that it's probably not 1 a.m., 2 a.m., 3 a.m., 4 a.m.?
It is safe to assume.
Alright, so this has been covered. So essentially, what I'm gonna go over today is, we can start with the Facebook. I'm not gonna read all of this.
When I was talking to attorneys last week, they did say that I should have been also served a notice of this hearing, the first one, before this was granted.
That's probably gonna be something you're gonna talk to about court now.
Okay. So whatever you're about to read me, I don't know what is involved in that, because I have this.
Which is
Is
this?
the injunction, and that's it.
Okay.
So this Facebook thing
Okay.
and all of that is not a part of
Correct,
this.
correct. Well, this is more motivation, more motivational is what I'm referring to. Is somewhere in here you say, you know, we'll just skip this. Honestly, it doesn't really matter.
The court thing, probably.
Thought I had.
But essentially, it's the injunction that I posted on my Facebook.
Is this the same injunction that's?
So it looks like this is the start of the injunction, and then this is the signed, or this is the order.
Okay,
But this is how it was handed to me.
so you do have,
So I just have the.
now did you appeal it?
So I'm going to on Tuesday. I didn't have all this information until I met with you, because we actually had our kid's birthday over the weekend, where we were, had a lot of kids with us over the weekend.
So you haven't filed for appeal yet?
It's not an appeal, but I have to file to request a hearing regarding this, but then.
But I think you only have 10 days to do that.
I don't know.
I believe.
I read that that a hearing happens within 10 days, and so I was going to do this on Friday, but I didn't know if it meant.
I think you just have to appeal in 10 days. I don't think the hearing necessarily has to be within 10 days. I could be wrong.
Well, I could be wrong too, but that's what I read. And also, I tried to do it online. They charge you $250, and then it was missing a signature. So I'm off on Tuesday. I'll be up there to handle this on Tuesday. But also, like the court stuff and this injunction, I guess they're going to be separate. One has to be handled here in like Maricopa Court.
Which one?
This injunction. I have to deal with this injunction before a federal case is filed, because it gets too murky, they say.
Okay, so one has, they have to find standing in one to proceed with it.
Yeah.
Well,
This is the request.
Okay, so I probably have to reprint it out. I was provided 3 emails that were sent, one on 1st, 2nd, 3rd, or 2nd, 3rd, 4th at varying times. To, I believe, Lineberry. I could be wrong about that, but it just says school employee. Essentially, what we went over, the asking to attend school events. Not only were they not sent during what would be considered normal working hours, school's out. School's been out. Mm-hmm. You made mention that they were automated. It specifically says no automated. Do you want to cover that at all?
I covered it.
Okay.
And I know we're all being recorded, so I don't know what I should say, because I've been made aware that I shouldn't say anything on that matter.
Okay.
I was told just to say what I've already said. I would take care of it. My IT guy set some things up. It was through an automated fashion, because they have set such stipulation that I was worried about missing something of my senior students, so we went through and we requested to attend any of the events.
Does he have any school events that would have been taking place that week? Or any event period for the school?
So, I'm not sure.
Hence the automated, regardless if there was or was not something, it was getting sent.
It was,
Okay, you see where that might be problematic? Especially since, so the reason I brought up the Facebook thing is because somewhere in here, once again, I'm not gonna find it because I don't know how much difference it's gonna make anyway. You allege that you are essentially going to use automated messages to, I don't know the exact phrasing.
it's in an email, actually.
Okay,
It's not in the text thing.
okay, so it wasn't mentioned on Facebook at all?
He's talking about, what number is that?
I'm assuming we're talking about the same thing?
Yeah,
I don't know what the heck happened out here.
It's in here.
No,
no. Number 2, this is it.
this is one of the emails?
This is your number 2 on the injunction where he says, the emails will be sent automatically for any game of any sport, for any grade, and any event taking place on MUSD properties, just in case I want to attend.
Okay, which I don't think anyone has a problem with, minus the school's not even in session. No one should be getting emails.
Yeah, I think you're just talking about, so these are the
I'm
reason.
talking about 3 very specific emails that I'm gonna try to pull them up here, so you can.
Okay, well, that one didn't even have.
Once again, sent on July, it was 1st, 2nd, 3rd, or 2nd, 3rd, 4th. One of the 2 at varying times throughout the early morning, 1, 2, 3 a.m.
I think what he's talking about is not on here. I think this is the reason for the injunction, and then a judge signed it on whatever day, and then he has, like, say this was signed June 30th, now they only have from June 30th on to, like, make the complaint.
So I don't care about any emails that were actually sent before June 30th at 10:57 a.m. because that doesn't make a difference. That's not why I'm here.
So
I'm strictly here for the violation of court order allegedly.
okay.
Now, if they were automated, did you have a chance to go through this when you were served? Did anyone explain, did you seek counsel from a lawyer the second you were served, or sometime during that day, or
Well,
the
this
next day,
was during a work day, right?
Okay.
So this was in front of all the patients and my staff, and so I didn't even know what she was there for.
Okay.
So she handed that to me. I have to be very careful, and we live in Globe, so it's not like even next day I can take care of stuff, because this is a public school, which allows me attorneys outside of Arizona, and mine is in Pennsylvania,
Okay.
and we're on different time frames.
Okay,
But he is the one that made me aware. I told him I think I can take care of this, or at least request the hearing. He doesn't need to fly and do all these things that cost me all this money. I think I can request the hearing. I've already submitted it. It just was missing a signature, so we'll go up on Friday
let me
or
print these
Tuesday.
out. I don't think there's any point in asking, do you remember sending them? Because I don't believe you knowingly sent them, as far as physically you were not the person who sent them.
Yeah.
It's the automation in the time.
Well, I already talked about this.
But that's a piece of paper.
So despite being one of the more specific injunctions I've seen, it was fairly easy to read. I mean, there was only a handful of stipulations. So this is what I was provided. Take particular note of the time and dates. I don't know what time school was out for the summer. But I can tell you that's not within a reasonable time frame to be sending emails. So that is mainly why I'm here. I need those back though. Did you want to address these or no?
So we already did address it, and you said to...
Automated.
You said, yeah, to get in there and make sure nothing else was coming out, and I think that nothing else is coming out, but I honestly, it's in a different platform than I'm used to, so I'm not used to it.
Where does one send automated emails from?
So one uses a program called Google Boomerang,
Okay.
and it's only like, I was gonna bring my laptop, but it's not even on my laptop, so for me to like dig through there, I think that I got them, but I honestly don't even know totally how to tell, but I can tell you that I cannot see any recurring ones coming out.
So you don't know they're being sent?
I'm just saying that this one, this one used to be all that was necessary of me forever. This is all that was sent every week until he realized they were automated. And then he had a big problem with it.
Okay.
So then it had to be specific to every single thing.
Yeah, I'm not gonna mention anything about the, I don't mind, whatever you guys settle is fine. I don't know why they specifically put automated.
I don't know
it's
why
not my injunction.
one can't simply scroll through something that normal people would.
Yeah, maybe it's because accidents like these happen, because you don't even know when they're being sent, therefore you
Does it matter if it's sent? I mean, at 1 in the morning or 8 in the morning? In order to comply with the ban, it was 2 days, how's it worded, 2 school days.
Yeah, the only reason that automated messages are pertinent to this investigation is because it says no automated emails. That is the only reason. Why they had an issue with that, I don't know. I have to go off of what the judge says. Since then, have you corrected the problem?
I believe so, but I'm hesitant to say. I mean, if I haven't, I'll be arrested, I guess. I don't fully know how to go through all of the...
I said this time you're not gonna be arrested. I didn't say you weren't getting charges, but you're not gonna be arrested. This is non-violent. I think the whole thing probably just needs to be talked about, but I do wanna read you some statutes.
In the injunction, I have a question that may be for you.
I may be able to.
On number 6, it says, defendant should be ordered to stay away from these locations at all times, even when I am not present. I guess it doesn't matter because it says even when they're not present, but who is I then?
I don't see a number 6.
On the itemized, maybe it's just the one that the judge had. These are the reasons he gave to the judge to have the injunction. It's
this may be a I as in Lineberry. I don't know.
I mean, that's what I'm assuming, but his name is nowhere on this injunction to know who I'm staying away from.
Yeah, then I really wouldn't be too worried about that one. Do not use, so residence or business. Yeah, so I'm not gonna interpret that. All I'm saying is nobody's alleging that you didn't follow that specific stipulation. So regardless of what your intentions are for this, I want you to read this.
Aggravated harassment thing?
Yes. Specifically number 1.
Okay, well, I've already read number 1, so.
So it states it's aggravated harassment if any of the following apply, right?
Mhm.
Person in favor of the victim of harassment and the order or injunction has been served and is still valid. You know this meets the criteria of aggravated harassment. This is a felony. This is no longer a hobby. This is no longer in your kid's best interest doing all of this. You please be careful. This is a very dumb reason, I believe.
I just want to explain why.
Like I said, there's a lot of backstory in this, and I know you feel justified in everything you're doing, and you believe it's serving a purpose, but it's having very real consequences right now. Now I'm forced to choose whether or not you get a felony or a misdemeanor. Because I can tell you if this happens again, it's going to be completely out of my hands, and you're getting a class 5 felony. A murder is only class 1.
So I did all of these things in this 30-page contact management plan for a year and a half, so I could attend my kids' things. I still have a kid in the district for another 4 years, and I've been a part of this district for more than 20. My oldest daughter is 27. All of them went through Miami schools. I've never had a complaint. Now I'm tired of being controlled and bullied. I'm being bullied by this man, honestly. So it probably comes down to me being arrested.
It's okay. Just relax. Like I said, you're not going to be arrested. Is this in your belief anyway? Is this simply just a matter of who threw the first punch, as far as it's making you look bad because they got the injunction on you first?
I don't care about looking bad anymore.
Right.
I don't.
No, I care about, once again, what's in the best interest of you and your family. And I can tell you, picking up felonies is not ever in the best interest of the family. Have you sought alternatives to make sure that you're not putting me in a position where I have to?
I honestly don't think any more emails are coming out. I guess I don't know how to.
I need a little bit more of a commitment than thinking.
So I
delete the program, get rid of your subscription, because if this happens again, without a doubt, I'm gonna have to hook you for a class 5 felony. And I think that is ridiculous, but I'm not the victim. I don't get to choose. Court says I have to follow this, that's what I'm gonna follow. All right? You need to make damn sure, I think, you need to go call the company if you have to and make sure that there is no more emails coming out. Once again, have you contemplated alternatives?
What do you mean?
As far as schooling?
I wish he would. I wish he would go somewhere else. Yes.
Okay.
I also don't know how to handle it because I don't think it's fair
I don't either.
either.
Nor am I recommending anything. Once again, my worry lies with you. I think this has gotten incredibly out of control, and
they already have targeted our youngest one, and he probably will end up going to Globe. But do you make him go away from his friends because this person needs to bully me?
The harassment really started on the other side. So,
They could. This ban is for nothing.
But I'm not reading an injunction you put against Lineberry, the school. You see what I'm saying? They, in a matter of speaking, they struck first.
Right.
So that's why I'm here. That's why you're here. Maybe next time. I mean, if you say this is going through court, it's going to take some time. But until then, this is good for a year, and it's going to be followed for a year minimum. That doesn't mean they can't. I mean, if they went through the Superior Court for this, it's good for 2 years.
They did go through Superior Court, right? Maricopa, is that Superior Court?
Why would they go through Maricopa?
Because he doesn't want his
Let me see what
laundry
it's
here.
actually.
It says Superior Court at the top.
That's weird. Does it say anywhere how long this is good for?
No. But apparently there was a trial that I didn't get to attend.
Okay. Yeah, I don't know anything about that. That's something you're gonna have to bring up with the court. Date of service on 6/28/22. I don't see anywhere how long it's good for. I'm going to assume a year, but you might want to check on that. Generally speaking, JPs are good for a year, and superiors are generally 2 years. But I don't see that here. I don't see any. So please convince me that this isn't going to happen again. at least with the automated emails and anything like that. Facebook posts, so what this essentially is doing, the only thing it proves is your intentions. So it's not, they didn't say anything about posting on Facebook as far as I know in the injunction. That's also not being alleged. What I was provided these because it's showing intention. You did exactly what you said you were going to do on Facebook. You said you were gonna use automated emails.
I didn't say I was gonna, I said I was using it.
Okay, was going to, did.
Long time ago. Long time ago I said.
Yeah, I mean, there's no statute of limitations on motivations. Once again, what you stated happened. That's where the Facebook comes in play. Nothing else. Other than that, I think, let me see here. Let me look up the other one. So just because there's an injunction on here, the felony aspect of this can come into play. So it can come into play. Let's see. Harassment subject in A. Anything under A is a class 1 misdemeanor. So essentially I'm gonna go with one of those. I don't know which one. I'm gonna give you a citation and cut you loose.
So the process that I think I understand just from asking is, I'm here today to show you the emails, and then you take the information that you gather and you write up a report and it goes somewhere else.
I write up what information I was provided.
And then when it goes somewhere else, they can decide what happens to me with this.
So essentially what a citation is going to do is, well, first, through these, I mean, undoubtedly probable cause. Undoubtedly, whether it was intentional or not, it broke.
I'm just asking what happens from here.
Then I take what information I have, goes into the report. When I cut you the citation, there's a court date. You just have to essentially deal with well, you have to reach out to the courts and before or on the date that I provide, and you either request a date of you want to contest it or you don't want to contest it.
Now, is this going to be filed in Maricopa where this is?
Nope. No, injunctions are good anywhere. So we even honor other states'
And in this hearing, do I bring my counsel? Because what happens at this hearing?
It's criminal in nature. So like I said, it's a class 1 misdemeanor. You're absolutely allowed to. That's a right you have. Whether you do or not is completely up to you.
Well, what are the?
So this court date is more about the misdemeanor, not the reasons for the injunction.
But then,
correct.
But then the decision leads to what?
So, two different things. One, the court is specifically going to go over 13, 29, 21. That is the actual statute for harassment. This constitutes harassment.
I guess I'm just asking, like, what are the
if you think
best and worst case? Like, they're not going to take me to jail.
Probably not.
Is there a fine?
That's up to the judge.
What is the word for repercussions in this?
There's ramifications for sure, which a lawyer is going to say. So you can choose to fight it, or contest it, or you can choose to plea it out. But that's going to be up to the lawyers. I don't know how that process works. It's basically magic once it leaves my desk. So I'm going to give you a date, but it's not going to be your court date. What it's going to be is the date that you have to contact the courts. So if you wait, a warrant pops out for you. And then we take you into custody and make you see a judge on it. If you just call, that court date could be 6 months from now. So the date that I'm going to give you is, I'll just make it 10 days out-ish. 1, 2, 3, 4, 5, 6, 7, 8, 9. I'll do, if you want to write this down, you'll also get a copy of it, July 26th, 22. to at 1 p.m.
This is, you're saying again, just the time
This
frame
is
that I
a-
have until,
No, this is just to simply contact the courts
yeah,
before
okay,
on that
that
date.
date.
They will either assign, I don't know how that works either, whether they assign you a court date right then, or they call you back saying, here's your court, your lawyers get together, come up with something, I don't know how that works. But I know they can go almost an infinite amount of time. I mean, there's a statute of limitations that they're gonna have to follow, which is 1 year for misdemeanors.
Okay, so I'm going to file this on Tuesday,
What are you filing?
the request for hearing, and then once you file the request for hearing, that's the Maricopa thing that I have to take care of before I can do anything else. Then they have 10 days, I'm gonna assume those are business days. If this injunction is deemed like not appropriate, does this other case matter?
Maybe.
Okay,
Once again, that's gonna be an interpretation well above my pay grade. I think what they're gonna look into, was it a valid order at the time I gave the ticket? And if they choose to dismiss it, then they choose to dismiss it. That's to the best of my ability, that's what it is. That's gonna be up to the courts. So let me, I don't have any here, of course. There it is.
God, this is so dumb. Look at how dumb this is. Right, that's what the one said, I'm recording, so, like, he knew what he was doing, because if he filed here, like, he's like, oh, it's Superior, that's weird, because he told me that if they would have filed it here, and then I would have filed it in Superior Court, then Superior Court trumps this. So that's why, it's so dumb, and I'm here because he got an email at 1 in the morning.
So as long as they stop, and in the end, we're probably gonna have to like pay attention to all of it now, and not just.
You can't tell me that I can't. You can't control
You doing that is a violation of the law. That's what I'm telling you. You're right, he shouldn't, but they did.
And I'm telling you that a judge out there somewhere signed this without really looking into any of it.
I mean, does it sound
Nobody
like
was
it's gonna
arguing
be
that.
like an actual injury, or is it just hurt?
The attorney said
Okay, you haven't told them yet.
I did already.
Okay, my
the weakest form of
suggestion
an
is,
injunction is the one you're not present
don't
for.
see a doctor, because that doctor
He said, this is
undeniably gonna say
gonna
you
be
can't train
overturned.
anymore.
All right.
Because you weren't there for it.
What they did for me, because I pulled my hamstring, I was a little further along, but they let me do alternative PT. Like I did the row machine for 2 weeks. I was probably at like week 13.
Dude, that's already way beyond.
It's up to them.
Like the second week
It's,
only, man.
it's up to them.
I'm gonna do that and look like lamed up.
You got a knee brace?
I did put a knee brace last week. It was actually the first week, and last
Can we
week.
just hang out and all of
Yeah.
us talk about work out?
And it was fine, but it just got worse.
Pop some pills.
Sorry?
Pop some pills.
I've been doing that.
Ice the crap out of it.
If it's just like a pain,
Yeah.
I can take pain, but this is, if you just put any pressure on going up the stairs.
Josh went through it. You can't hear it. Ooh. So, do you have any questions as of right now? Okay. So this is fairly good news. Because if I didn't see any effort on your part whatsoever to try and correct this, I can tell you which route I'd be going right now. I don't see that, and I hope this isn't gonna be an issue any longer. So you not knowing that the emails were sent, as far as I'm concerned, judge may feel differently. It doesn't matter. The restraining order was broke, or the injunction was violated, almost undoubtedly. So please just make sure that that's not gonna be an issue If you're gonna fight them, then fight the good fight. But doing this is not gonna help the cause.
Doing this, the emails?
Or
Or-
emails. Is that you? Just left the desk by the way. Do you have an idea on me?
I didn't, it's nowhere. I mean, I have an idea, I can tell you the number if you want it.
Let's take your spelling last name first.
Pettitt.
First name spelling.
Michelle.
You have your number?
Yeah, AZD01964-728.
Try that. Alright, I found you. Do you have any questions for me?
No.
Okay.
Came prepared to go to jail, so I brought a bean burrow and a
No,
smoothie.
no. If you were going to jail, I would have just told you. I have no problem telling somebody that. Like I said, being nonviolent, your criminal history is more or less fine. So I don't see a reason to put you through that.
Emails aren't even harassing.
It's unfortunately
I get emails
that's not
all
the
day.
point though. That's the only thing I'm concerned about is that it doesn't matter. It doesn't even matter who's in the right at this point. You know, when you get a court order on him that says whatever it says and he violates it, he's going to be in the seat next. And he does not like being in the seat. I can tell you that. Is 742 First Ave still a
Yes.
valid residence? Is that mailing and physical?
Yes.
Okay. No.
When you speak to them, do you speak to all of them or just him? Well, there's really two. I mean, do you speak to the two?
I haven't had the need to speak to either of them because they're going through a third-party lawyer. So really, he provided me all the information. I haven't even had to talk to him.
Their lawyers are definitely different than mine.
And the thing that worries me is even if I email them and ask them a question for her, now she's violated the
Correct.
claim because.
Correct. You cannot have somebody talk to somebody on your behalf, on her behalf, rather. Otherwise, that would, you know, I deal with that a lot too. They're like, well, I didn't break it. Well, that's not the world's biggest loophole you just stumbled upon. That's part of the injunction.
Yeah.
Otherwise,
It's ridiculous.
yeah.
Because I could set up automated emails and not violate it, but still be annoying.
I know it doesn't matter anymore.
They were very specific with the injunction.
But I realize that you kind of have to be crazy to rally your troops when this is going to be like a bigger thing, but their lawyers are willing to write anything and mine are not. So this letter from my attorney said, I think you should just send the exact same 5 to 7 word requests you sent that worked before each event. You can identify all school events, it seems, on the school's calendar online here.
When was that sent though?
This was like last year. So he's just saying, you know, this worked for so long, right? I sent that. I'm requesting to attend. I know we're arguing over something that doesn't matter. I just want you to know I did what worked for a while. Then he wasn't satisfied with that anymore. He needed me to address him every single day of my life. And my lawyer says, I'm not willing to write a letter for you quibbling with their accusations because I think doing so would cause more harm than help. But his lawyers just write whatever.
Well, they did it in, they may have written whatever, but they did it in an official way. Sending him a copy of whatever you think isn't gonna help. You got it, I mean, you can go get an injunction against him, assuming that the judge permits it.
I mean, I don't want it, there's no reason. I just need to be able to safely, and I just need to be able to be a part of my kids' life without all of this.
And they stipulated you can view it as reasonable or unreasonable, but they stipulated what you can and can't do. And it sounds like as long as that is followed, then
No,
there
yes,
shouldn't be
they
any
said,
issues.
I shall not go to or near plaintiff's employers or other protected person's workplace ever, whether he's there or not. So that directly contradicts what the parent contact management plans. This says I can never be on school grounds.
This is gonna trump whatever was previously discussed.
Right, so in one line it says you have to comply with the current plan, and then on another line it
I'm
says,
confused about that part. That's something you would have to take up with his lawyer.
Well, if
or-
we
or
played
your
it out,
lawyer.
I
let's-
can't even contact the lawyers.
So I know this is annoying. It's annoying to me
No,
too.
it's all right.
But if I were to take my kid to school, this says I can't go near the MUSD whether he's there or not. I can't take my kid to school. So on number 1 in the other it says comply with the plan. On the next line that's highlighted it says can't go near any of those places that are checked. So it's not just a matter of emails.
I mean, the biggest gist of what I got for this, as long as it's pertaining to your kid during normal school hours, you're permitted to do certain things. I don't think that's an unreasonable request to drop your kid off at school.
Defendant should be ordered to stay away from these locations at all times, even when I am not present. His residence, his work, and the school.
If that's what it said, well, that's something that needs to be contested then, if that's a worry of yours. I'm just worried that it wasn't done within 10 days.
I mean, school starts like, what, first week of August?
Yeah. So, yeah, that's definitely something that's gonna have to be covered.
I don't know if you've ever been through like major litigation, but nothing happens fast, at least in this, nothing's happening fast.
Getting an answer as far as interpretation on those is generally pretty fast. What's a good phone number for you?
928
928
813
813
2522.
Mailing address same as residential,
Mhm.
physical.
Yeah. And you're saying getting the answer to this is easy, and that's through court to have them like word it different or better?
I would try with your lawyer, his interpretation first. And then if there are any concerns, I'm imagining he is going to reach out. I don't know anyone at the court besides the judge that could interpret that because he's the one that wrote it.
Hopefully I pissed off the judge the other night. Right, Superior Court in Gila County.
Oh. I think it was my fault.
No, he's
Oh,
writing the
this
ticket
one.
for here.
Oh.
Yeah,
Yeah.
right.
And is that Superior Court or lower court?
It's just a misdemeanor, so it's gonna be.
Okay, well, I guess I don't know the women there. Do his lawyers seem really mean?
You know, I talked to him briefly, and
There's
it
a
was
lot of
mainly
them.
just to get an email address out of me.
There's a lot of them. He has like 6 lawyers. That he's not paying for. I'll add that.
Yeah, I can imagine that can be a tough part too.
So I guess I don't need you to take off for that court, but probably this one.
So you'll be getting a copy of this. So exactly what we talked about, the 132921A1. So you can look that up. Other than that, 7/26 of 22, just contact this court before or on that date. Otherwise, you're probably gonna end up getting a warrant. So if you wanna go ahead and sign there on the left-hand side, you're not admitting guilt, you're just simply saying you're gonna take care of it before. And I will give you a copy of this. Any questions? Okay. Nothing? All right. Best of luck to you. Please just remember what I told you.
I know it's
I
know
don't
it's
wanna-
this.
I don't wanna go there.
It's like we fix this, it's gonna be something else. So
No comment. I don't know.
thank you.
Of course. If you do have any questions, you can feel free to give me a call.
Sorry we were late. We honestly.
No, it's okay. Showed up, that's what counts.
They just leave their cars running. Is there someone in there, or they just leave their cars running?
So they don't have to get into a hot car. They ain't paying for it. Do the same thing at work. More than I thought we were showing up for.
It's very complicated because on one hand he's like, this is voluntary, you can leave. Then it's like, if you leave, then here's my impression of you and it's gonna go in this report.
Well, no, in that aspect, if like you cussed him out and you walked away, he's just gonna arrest you with the felony. Like maybe not right then. You can get up and you can leave, but I will serve you something. So I kind of understood.
I mean, I think he thinks it's ridiculous as we do. He just doesn't know all
He's just
of
gonna
what
follow the
has
law,
gone on.
Like even that's why he kept saying like I know there's more to this. This is my aspect and this is what I have to do, or what he has to do, right? If he's told somebody's committed a crime, doesn't matter what it is, he has to, even if it is